All right, welcome back. This is the second presentation of Chapter 4, Civil Liberties. We're going to deal more and more with the idea of freedom of expression and what kinds of expressions are protected and what kinds of speech acts are not protected. So let's jump in. So, First Amendment guarantees both freedom of and freedom from religion. So that raises two important questions. In what ways does the First Amendment seek to preserve freedom of religion? The two clauses kind of preserve, the one hand, the Establishment Clause says that the government can't tell you how to believe. Likewise, in terms of freedom of religious belief, the government can't tell you how to worship. So the Establishment Clause has three possible interpretations. One, its intention was to prohibit the federal government from establishing an official church, which was common at the time in Europe. Two, the Establishment Clause can be read to imply that governments may provide help to religious institutions, but may not do so in a way that favors any one religious creed. In other words, the state is enjoined from picking winners and losers as it relates to religion. And three, the idea that the Establishment Clause erects a wall of separation between the church and state. So the second question is, in what ways can the First Amendment's religious protections create conflict? Two particular areas of dispute regarding the Establishment Clause are in public education, obviously, where the courts have ruled that organized religious activities, even when they're non-denominational, can imply sponsorship in a way that creates an unnecessary entanglement of church and state. And two, the second area of conflict concerns public display of religious symbols. The example of where busts of the Ten Commandments have been placed in state courthouses and on state grounds is a good illustration of the difficulties inherent in parsing what constitutes a public endorsement of religion. Where a Ten Commandments display outside the Texas state capitol didn't violate the First Amendment, displaying Ten Commandments inside a Kentucky courtroom was interpreted as violating the First Amendment. So again, this sort of highlights the sense in which there is this rather narrow ground that the state is enjoined from really stepping into. The First Amendment's freedom of speech and of the press ensure the free exchange of ideas. Democracy is really not tenable unless free and open debate is protected. Freedom of speech is often portrayed as a marketplace of ideas deserving of maximum protection from the courts. In a 1938 Supreme Court decision, the court held any legislation restricting speech is subjected to the most exacting judicial scrutiny than are most other types of legislation. The statement quoted is one of the most famous footnotes in Supreme Court history. The case was the United States versus Caroline Products Company, and it's footnote 4. That again establishes what is known as the strict scrutiny standard of review, and again there the presumption of the court is that what the state is doing is wrong, and the state has to prove that it's that what it's doing doesn't run afoul of the First Amendment protections. Over the years, the Supreme Court has elaborated several tests to determine whether speech lies beyond the scope of constitutional protection. One thing that's been happening, again, at the state level are these anti-woke laws that are basically saying, the state is saying that you can't teach certain ideas, or you can't teach in such a way that makes someone feel bad. Recently, the federal circuit court has basically held that Florida's "Don't Say Woke" law was basically a violation of the First Amendment, and so that's very consequential and important. Political speech is generally viewed as most worthy of protection, but it's also most difficult for the politically powerful to tolerate. For example, in 1798, Congress passed the Alien and Sedition Acts, which basically was designed to suppress criticism that was emanating from the Adams administration conduct of what was known as the quasi-war between the United States and France. During World War I, the Supreme Court established what was known as the clear and present danger test to uphold convictions under the Espionage Act. Basically, the argument was you can't shout fire in a crowded building, which one of the great Supreme Court justices, Oliver Wendell Holmes, later said he regretted that decision because he felt like the test opened the door to too much restrictive speech. Political speech is generally accorded the highest protection, even when it may reasonably be viewed as insulting or outrageous, something that we're witnessing every day in our political discourse. In 2010, the Citizens United versus the Federal Election Commission, the court struck down bans on corporate funding of political advertising supporting or opposing candidates. And again, that has opened the door to massive amounts of spending. And again, I'm not generally against campaign spending, but the reality is that if money is speech, then the wealthy has more speech than everybody else. And so if there's not a way to level the playing field somehow, then the wealthy get a disproportionate amount of attention. Fighting words and hate speech, these are two examples of speech that lose constitutional protection when it crosses into the realm of expressive speech that's defined as directly designed and calculated to incite violence. However, in Dennis versus United States, 1951, the Supreme Court concluded that there is no substantial interest in permitting certain kinds of speech, including fighting words. Such fighting words may frequently result in arrest, particularly when it's aimed at law enforcement. The challenge of the right to express controversial ideas and the desire, for example, of university professors to suppress hate speech and promote campus security is often one of those things that create a lot of conflict in how we monitor speech. We're seeing that right now, again, with a lot of anti-Semitic speech on certain college campuses. Privately owned social media companies have gone through rounds where they've attempted to prevent the spread of hate speech and misinformation through what is known as deplatforming, where you basically kick people off. Of course, Donald Trump was kicked off Twitter for that kind of thing. Student speech, again, we mentioned this in the previous presentation. The federal courts have generally backed away from broad extensions of student speech in public high schools. School administrators need broad latitude to teach students the limits of socially accepted behavior. And I mentioned the infamous Bong Hits for Jesus case. And again, there the Supreme Court ruled that the First Amendment did not require schools to tolerate students advocating illegal drug use. And again, at the time, marijuana use was illegal in Alaska. It probably still is in Alaska, I don't know. Commercial speech is generally considered to lie entirely outside the protection of the First Amendment and is subject to limited regulation. The Federal Trade Commission's prohibition of false and misleading advertising is well established, and again, it goes back to the old days of snake oil, where these people would sell basically what was wood alcohol soaked with tobacco and claim it's some magic elixir at state fairs. The Supreme Court has upheld city ordinances prohibiting the posting of all commercial signs on publicly owned property. Such city ordinance bans must be comprehensive to avoid, again, the appearance of selective censorship. As the line between commercial and political speech has blurred, courts have found some speech to be protected by the First Amendment. In 1975, the court struck down a state law making it a misdemeanor to sell or circulate newspapers encouraging abortions. And in the case Bigelow versus Virginia, that involved a case where Jeffrey Bigelow, a newspaper editor, was charged under a Virginia law making it a crime to encourage abortions. And this case actually preceded Roe versus Wade, but the decision was actually handed down a year later, with Associate Justice Harry Blackmun writing for the majority that the First Amendment should prevent states from prohibiting advertisements of products or conduct that is clearly legal at the place advertised. Symbolic speech, speech plus, and the rights of assembly and petition. The courts have also always protected an individual's right to symbolic speech. Classic case there in Texas versus Johnson. Gregory Johnson burned the American flag outside the Republican National Convention. That is considered protective speech. It is offensive, but it is nevertheless protected. Speech plus combines speech with activities like picketing, distributing leaflets, or other forms of peaceful demonstration. In Hague versus Committee for Industrial Organization, 1939, the Supreme Court held that government may take measures to protect public safety, but could not prohibit speech-related activities in public areas traditionally used for such purposes. What often happens is they will designate a place for people to protest these days. Protest activity on private property is an entirely different matter and can be subject to aggressive regulation. Freedom of the press, again, since the Supreme Court's decision in Neer versus Minnesota in 1931, only under the most exceptional circumstances can government engage in what is known as, prior restraint, which is, in other words, censorship. The Supreme Court has also held that the right of the press to publish extends to issues touching on national security, with New York Times versus United States, which dealt with the release of the Pentagon Papers, which was a confidential study conducted by the Rand Corporation on behalf of the Defense Department, which basically said that the United States was losing the war in Vietnam. And the Nixon administration attempted to suppress that publication on national security grounds. The court held that people have a right to know whether a war is going well or not. There's another aspect to this, again, regarding freedom of the press. Journalists lack protection, what is known as shield laws, with a shield law, a journalist can't be arrested for withholding the sources of a story. And that has actually occurred in numerous instances where journalists have been jailed for contempt of court. I think a lot of media scholars would agree that a federal shield law would help protect the First Amendment, the right of freedom of the press. Libel and slander, and again, libel and slander are both not protected by the First Amendment and can result in civil penalties if statements are malicious, scandalous, and defamatory, and or are published with a reckless disregard for the truth. And of course, what we saw with the Dominion case aimed at Fox News is a good example of that. The bar is extremely high for a politician or other public figure to win a libel lawsuit. The libel standard was established in New York Times versus Sullivan, and again, it reflected the sense in which the New York Times was actually being sued along with the Southern Christian Leadership Conference. And, again, the idea there was that you had to, that a mere mistake in a printed story is not sufficient to establish that a person has been libeled. And so, again, it creates this idea that you have a very high bar in order to actually justify a libel verdict where the person is a public figure. Again, if you look at what happened with Trump regarding who was, again, the woman E. Jean Carroll, the woman that he was sued by, she was a public figure. She was a journalist. She was a freelance reporter. But nevertheless, she was able to demonstrate that he had, in fact, damaged her reputation and won upwards of, I believe, by now, close to $88 million in civil damages. So that's, very, very substantial penalty, even for someone with as much money as Donald Trump. So that's it for this presentation. When we get back, we will continue our discussion of civil liberties. See you next time.